Where your lordship,
Yes,
lordship, item number 6, your lordship.
yes.
The counsel for the appellant, she's stuck at traffic, your lordship, so not being able to reach you. So this matter may be listed on Wednesday.
Wednesday, why
Yes.
so early? Any urgency in the matter?
I have been instructed to make a prayer, your lordship, for Wednesday by counsel for the
What
appellant.
is the matter?
Regarding appointment. The appointment of the appellant very well set aside.
Okay. In which post?
LDC.
On what ground it was set aside?
I secured more marks. I was the repetition.
You are now working.
Yes, consequent to the judgment of the largest because I have been now appointed.
Okay. Not Wednesday, after 2 weeks. We are ready to do the case today. But there is a traffic issue. He can't reach, so we'll list it after 2 weeks.
Obliged.
Traffic will be much better by that time.
Oh,
On the prayer of yes. And Anju, you are praying on behalf of whom?
And Duncan,
And Daniel on council for the appeal and list it after 2 weeks.
obliged.
Well, this is relating to Police Accountability Commission.
Hmm.
Two instructions were sought for. Then His Lordship H.N. Sharma was recommended for appointment, but he has refused. And thereafter, no instruction has come. And secondly, my lord, that identification of the list of investigating agency officers. Separation of.
What is to be done today?
I don't know, brother Tapin must be having some instructions today.
I may be given to understand. Here also, as per the Bible instruction. The chairperson is only given the consent for appointment as a chairman of the police company. Sent to the government for implement.
Okay. Who is the chairman?
Police complaint authority,
Ah,
the chairman it is to be appointed from the law
I think,
secretary.
okay. Whose name has been proposed?
SC, this was.
Justice D. Biswas. D. Biswas.
It is on record.
No, it's verbal.
Okay.
Let the instruction come, my lord. And in the meantime, also,
Otherwise, was earlier was as per our affidavit, offer was given to Justice
H.N. Sharma.
H.N. Sharma. In the meantime, it has been changed and.
4 weeks
Once this commission comes into my lord,
on the prayer of the council for the parties. On the prayer of Mr. S. Tapin Lamika, senior government listed up to 4 weeks. To enable him to receive up to date instruction in the matter.
correct, grateful.
Yes, I mean. My lord, this PIL, my lord, has been filed, my lord, seeking direction, my lord, framing of rule, my lord, in terms of the Arunachal Pradesh Freedom of Religion Act 1978, my lord.
Council for the state was Aris now, is stuck in the.
Okay. Otherwise, the affidavit is in file. That is-
File.
Why the rule is necessary in this case?
My lord, yes, my last occasion, my lord, put a pertaining query to me, my lord, is this, the word used here is may, my lord.
Huh?
The word, my lord, the rule, section under which rule need to
See,
be.
rule, framing of the rule is not a mandatory proposition.
Yes, my lord.
If there are difficulties in the working of the act,
Right.
then there usually a provision in the act that the government may make rules for carrying out the object and purpose and the provisions of the act. Is not it?
Yes, my lord.
No, where is the difficulty without the rule that this act cannot be, that this act is not workable?
Yes, my lord. My lord, that is my humble submission, my lord. So that is, here is the objective, my lord. To implement a very objective, my lord, rule is necessary, my lord, in this case, mandatory, my lord.
Why?
My lord, broadly, my lord, this, if we look into this act, my lord, this act has the main objective of this act, my lord, is to prohibit conversion, my lord. Additionally, my lord, yes, in this act, there is a provision, my lord, for punishment, my lord. But then, my lord, my humble son, main objective of this is under this act is to prohibit the conversion, my lord. Now, that is deal in section 5, my lord. Under section 5 is no, if no rule is framed, my lord, this section 5 cannot be implemented, my lord. The punishment section, my lord, punishing section is a auxiliary objective of this act, my lord. The main objective of this act is to prohibit the conversion, my lord. Now, that conversion, if my lord, this section 5 is the main, I would say my lord, main provision, my lord, to prohibit the conversion, my lord. Now, for this implementation of this section 5, my lord, the rule under 8 is necessary, my lord. So my humble submission, my lord, this must, this may, my lord, need to be, and surely intention of the legislature is sale, my lord, in this case, my lord.
What is the stand of the government in the affidavit?
Government is saying, they are simply saying, as this is a legislation of 1978, my lord. Now they need to, my lord, look into the present situation, my lord. Present situation, my lord. What is the present situation, and they need to consult from the stakeholder, my lord. Now that cannot be, my lord. How executive can, my lord, deny the command of the legislation, my lord? That would not be, my lord.
Last time also I had pointed out this.
My lord.
That even without the rule, this act is workable.
Not, my lord. Main objective is not, my lord.
How?
My lord, if my lord allow me to read, my lord.
What is the object of this act?
Act is to prohibit, my lord, conversion to religion, my lord.
To prohibit forceful, fraudulent conversion as well as conversion by inducement.
My lord.
Where is the empirical data
My lord.
that such and such person, so many of persons of the indigenous faith believer have been converted by anybody to another religion, either by force or fraud or by inducement? Where is that data?
My humble
Second, even if there has been such instance, you have the remedy of filing a complaint against a particular person who is indulging in such activities, which has been made punishable under section 4.
My lord.
Have you lodged any complaint before
No.
anybody? So there is no any conversion by force, fraud, or inducement.
My lord, my humble answer to past query, my lord.
Today, yes.
Past query to my lord. Now, the very objective, my lord. The my lord had raised a patterning question in there. Now, section 5, my lord, very objective to determine, my lord, what is how many percent is conversion. For that, this section 5 has been brought in, my lord. Now, in absence of this, my lord.
Just a moment. Section 3, no person shall convert or attempt to convert either directly or otherwise, etc. Prohibited. Section 4, prescribes penalty. Any person contravening the provisions of section 3 shall, without prejudice to any civil liability, be punishable with imprisonment to the extent of 2 years and fine up to 10. Isn't it? Come to section 5. That offense has been made cognizable, which means
No, my lord. Section 6 is section 5 with the party.
an offense under this act shall be cognizable. Which offense? 3 and 4. And shall not be investigated by an officer below the rank of an inspector. Offense has been made cognizable. You can go to the police station, lodge an FIR under this provision. Now, when that FIR is lodged, under normal criminal case, who investigates it? Sub-inspector. Here you have been provided with a higher authority. Inspector of police shall investigate. So it is workable.
No,
See, if you have any, if you come across any instance of conversion by force, fraud and inducement, you can prevent them through this act without the aid of the rule. So where is the necessity of the rule?
my humble sir, that time I am saying, my lord, this penal provision, my lord, under this act is an auxiliary objective of this act, my lord. The main objective, my lord, is to prohibit a conversion, my lord. This penal, this I say I submitted this penal provision is workable, my lord. But that is not the main objective of this act, my lord. The main objective of this act is to prohibit the conversion, my lord. That has been dealt under section 5, my lord.
Where is the conversion, Mr.?
My lord,
Where is the conversion? It is your wishful thinking. It is the wishful thinking of this petitioner.
no, my
In
lord.
the absence of any instances you have narrated in the petition, that such conversion is taking place.
My humble submission, my lord. As the rule is absent, my lord, that's why, my lord, there is no data at all, my lord, about the conversion, my lord. In absence of this rule, my lord, this data is not available, my lord. Whereas if
You think about this matter.
Hmm.
I have pointed it out last time also.
yes, my truly.
Today, had RS Navam been present, we could have closed this PIL. Unless you answer these questions, on the next day, we will close this.
My lord, I suppose.
Mr. L. Parnell, our petitioner. Mr. Kapil, Senior Government Advocate, informs that Mr. RS Navam, an additional advocate general, will appear in this case, who has not yet reached the court premises due to traffic congestion. In view of the above listed after 6 weeks. Think about it. Huh?
4 weeks, my lord.
4 weeks.
Obviously.
My lord, this appeal was against the interim order passed by the learned single judgment. Now that repetition has been closed. my lord.
Okay, it has become in process.
Yeah, yes.
Okay, Mr. D. Sogil, counsel for the appeal. Promised that this appeal has become in process. In view of the submission made, this appeal is stands closed and in process.
Okay.
I also closed in view of all of us.
Your Lordship, in this matter, the registrar has received the LCR. Paper needs to be.
Okay. Anju is for the appellant.
For N-Bank. NS.
Okay. Then the council for the person is that the LCR has been met. As indicated in the OM not office note dated 1/8/2023, in view of the registry shall prepare the paperwork and list it thereafter.
Keep it.
Your Lordship, this I application was filed by LSC, Your Lordship, Jayatoji. Due to some ill health, she could not make it today. So I'm representing on her behalf. This I application has been filed for correction of clerical error, Your Lordship.
All right, how Ms. L. Anju, the counsel for the applicant and Ms. He's in APP. This is an application for correction of miscase number recorded in the order dated 25/7/2023, passed in criminal appeal 4 of 2023, wherein the miscase filed by the appellant in sessions case number 58/14 within bracket YPA has been recorded as miscase number 02/2013, whereas the miscase number
02 of 20.
is whereas the miscase filed in sessions case number 58/14 YPA is miscase number 02/2023. Full stop. We have perused the record where the miscase filed in sessions case number 58/14 YPA is found to be miscase number 02/2023. In view of the above, it is hereby provided that the miscase number 02/2023 recorded in the order dated 25/7/2023, passed in criminal appeal /04/2023 shall be read as miscase number 02/2023. That will do. Highest instance disposed of with the above direction.
Highly obliged.
Then stand corrected in a red as.
My lord, I beg to mention item number 6.
Yes,
I'm praying for some more time to file the rejoinder. Taken the consent from the other side also.
okay. Mr.
B Nyarus.
Mr.
B Nyarus.
Okay, your name is not there in Bagalatnama. B, sorry.
It's not reflected in the cost.
B, Nyori.
Nyarus.
Yaros, council. For the petitioner, priest for the granted for the 4 weeks time to file counter evidence. Listed up to 6 weeks.
Much obliged.
Your Lordship, item 25, my lord. Record was called and this, they have sent partially, my lord. So I have called them again, my lord. I have taken this consent from this Ajin Apang sir also. Let me place the record on this coming Wednesday, my lord, next Wednesday, my lord.
What is the matter about?
It is about termination, my lord.
Termination.
Termination of service shiksha contextual teacher, my lord.
When do you want?
Next Wednesday or Thursday, my lord.
We'll say after 2 weeks.
Lordship, fixed date may be given, your lordship, because
Huh?
fixed date may be given because this is a long pending case, your lordship.
Yes.
This is for supplement.
What
for
was
hearing.
the record is called?
Record was, they have insisted for the, this record of inquiry, my lord. Proceeding, disciplinary proceeding, whereas in our opinion, there should not be any disciplinary proceeding in such contextual matter. Nonetheless, they have called for and court also asked me, directed me, my lord.
Okay. After a week.
Lordship,
ma'am.
can it be on,
My lord, 10, ma'am.
10th of May.
10.
August. All right.
obliged?
10th of August.
Yeah, my lord. My lord, I beg to mention item number 12, my lord.
12.
Matter may be fixed after 2 weeks, my lord.
What is the matter about?
Actually, my lord, this is a land dispute as per my understanding, my lord. In this case, petitioner has challenged against the order passed by ADC Pasigat, my lord.
You are making a mention for on behalf of whom? Petitioner.
A respondent, my lord.
Who is for the petitioner? Have you informed the council for the petitioner?
Yes, my lord.
Okay. Which respondent?
Respondent number 4, my lord.
Okay, your name?
N Noble.
N.
Noble, my lord.
Novin.
Noble, my lord.
NOBENG.
ENG.
Mr. N. Novin, London Council for respondent number 4.
4, yes.
with the consent of the learned counsel for the petitioner. Press on the prayer of the constitutional list it up to 6 weeks.
2 weeks, my lord.
Why 2 weeks? What for? What is the urgency?
No, no, it's okay, my lord. 6 weeks.
Ah.
And my lord, I beg to mention,
8 weeks, if there's no urgency. We'll attend to the urgent case, 8 weeks, yes,
8 weeks.
8 weeks.
And my lord, I beg to mention item number 24, my lord.
24. Yes,
Actually, my lord, in this case, I have no idea, but some this matter may be listed after 2 weeks, my lord.
you are appearing on behalf of whom?
Petitioner, my lord. T. Taba.
What is the matter about?
Apology, my lord, I have no idea.
Then you'll have to wait.
My lord,
I have taken consent from my lord. Another party also.
You are for the respondent.
no, in item number 12, my lord, I am the,
12.
Three, whatever.
Okay. Your name?
M sort of.
On the prayer of Mr. M. Sora, learned counsel, appearing on behalf of Mr. K. Ronan, learned counsel for the private respondent. With the consent of Mr. T. T. Tara, learned counsel petitioner, listed after 4 weeks.
Fine, there is first stay order.
My lord, I beg to mention one unlisted matter for today, my lord.
Eviction.
Eviction matter, my lord. It was,
Take it up tomorrow, you file it. You
Well-
file it, you file it.
my lord, eviction may be carried out anytime soon.
That was the position yesterday also.
Yes,
We had given you an opportunity yesterday.
yes,
We took it up. You file it, it will be listed.
my lord. Tomorrow, my lord.
Ah.
Obliged, my lord.
My lord. I beg to mention item number 17. Mr. Opad, leading counsel, Mr. Opada is out of station.
Yes,
Pleading are completed. Matter may fix for admission hearing.
okay. On the prayer of Miss
Christina C. Tabang,
C.
Tabang, TAVING.
Okay. Learned counsel. On behalf of Mr. O. Father, learned counsel for the petition, listed after 4 weeks for admission hearing.
Massive.
Lordship, I would like to mention item number 15. Initially, this is Hotel Benjamin. Initially, this case was initiated by the Justice Surana. So Justice Surana is coming after 14 of this month. So I pray to adjourn for today and list matter after 15 of this month. So that initially Justice Surana taken up this matter, he put his photo in the letter.
Justice Surana is coming.
Yes,
When?
after 14,
After 14.
yes.
When do you want the matter to be listed?
15 or 16, any 15.
On,
On
on
14th, he will available in bench.
Will available. in this case.
Yes, before December.
50 will be holiday.
14 age per roster. After the 14, he will be here.
This is a part heard matter. Part heard matter by Justice Surana.
Yes,
We will adjourn the matter.
yes, 14 age per roster, 14 8 to 18 8. No, no.
But it is a part heard matter. No.
No.
Okay. How do you know he is coming?
Ma'am. The fact of the case is that this writ petitioner has filed an RTI, my lord. Before the PIO come, my lord. Executive Engineer RWD Chang Tajo Division is coming this to come. Now, my lord, the information was not provided to the petitioner.
Information was not provided to the petitioner
Yes, my lord.
by the PIO.
PIO. And he went to the first appellate authority.
Okay.
Even there, the information was not provided. Then he went to the second appellate authority, that is the State Information Commission. Now, during the entire proceeding, the PIO never appeared before the commission. But he submits an affidavit.
Where in the commission?
Yes, before the commission,
Yes.
but not during the proceeding.
Not during the proceeding.
Yes, madam.
Okay.
Madam, page 53, madam.
But before the order was passed.
Yes, sir, before the order was.
Page 53.
Page 53, madam. He states, madam. This PIO, private hospital of 3, madam, that I am the PIO of RWD Changtajo is coming district, so and so. That the PMGSY project, Jeju Daja to Tagang Warang is under my jurisdiction. That during taking over of charge, I had not received any related document of the project from the then EEPIO. DPR sanctioned tender document and are not maintained under my office. That I could not furnish the document as sought by the appellate so and so due to non-ability of report props number 1 to 3. Now, how is it possible, Bhagat? The outgoing incumbent cannot take away the file with himself, Bhagat.
Just the during
the submission of the respondent PIO, the commission observes that no mala fide is established on the part of the respondent PIO and no case is made out for taking further action against him. The commission further observes that the documents which are not available or which are not under the control of the PIO cannot be disclosed and resultantly there is no disclosure obligation on the PIO. The commission accepts the explanation of the PIO. No further action lies. The matter is disposed of and closed. No, my lord. What I say, my lord, the outgoing executive engineer, how can he take away the file with him, my lord? If suppose one CO is posted in UPR, tomorrow he is transferred to my lord, Namsai. How can he take the file of the UPR to Namsai, my lord?
What information was sought?
Information, my lord, is page 28, my lord.
Yes, Mr. Seke.
Yes, my lord. My lord, the commission is followed the, my lord, all the provisions of the scheme of the RTA, my lord. In fact, my lord, for non-appearance of the, my lord, PIO, a so-called notice was also issued to my lord, to the, my lord, PIO on, my lord, 28/10/2023, lordship will find at page 42, my lord. Thereafter, again, he has failed to, my lord, appear and comply to, my lord, furnish the information, my lord. Therefore, my lord, by an order dated, my lord, 73/2023, impose a, my lord, penalty of 25,000, my lord. Thereafter, again, my lord, a date was fixed. The PI has not appeared. For another, my lord, notice was issued for initiating, my lord, receipt proceeding under my under section 22 of the.
That part is all right.
All right, ma'am.
That part-
Thereafter, my lord, before the next date is fixed, that is, my lord, 23/6/2023, my lord. From the order of the final order of the, my lord, the commission, it reveals, my lord, at page 56, my lord. The affidavit was part of the written statement filed by the PIO, my lord. My lord, second paragraph, my lord, page 56, my lord. The respondent PIO is not present during the hearing. A written reply dated 2/6/2023 has been received from the respondent PIO. In his reply, the respondent PIO has submitted that accept the order dated 17/3/2023 imposing a penalty of 25,000 on him. No, any other orders of commission was received by him. Hence, there was no willful disobedience on his part to comply with the orders and directions of the commission. He has further submitted that the sought information cannot be furnished to the appellant as the same is not available with him. He has also submitted an affidavit filed before the executive magistrate Ethanol Capital Complex, wherein it is clearly stated that the related documents of the project were not handed over to him by E. Siang Tazo when he took over the charge of the office. He also paid the penalty of rupees 25,000 in SBI account. Such and such copy of the journal has been received from the respondent or PI. Well, basing on the written statement, my lord, the commission has passed, my lord, this order, my lord. My lord, saying that, my lord, there is no obligation on the part of, my lord, the PIO, the information which is not available within, my lord. Now, my lord, the information
8.
Yes,
Yes, my lord.
8
Yes, 8.
in its decision.
Yes, my lord.
Which clause?
My lord, A.
A.
Yes, ma'am. Has the power to require the public authority to take any such steps as may be necessary to secure compliance with the provision of this act, including by providing access to information if so requested in a particular form, my lord. My lord, even if it is submitted by the private respiratory, the PIO, my lord, that the documents is not with him, my lord, the chief engineer, my lord, or the appropriate authority should have been called for, my lord, for compliance, my lord. I cannot be made remediless, my lord. I've sought for an information that has to be provided. Now, this, my lord, this affidavit is completely a lie, my lord. Why? Because, my lord, how a officer, my lord, the outgoing officer can take away the file with him, my lord. Then why they have not filed any FIR against that outgoing authority, my lord? For now, my lord, I pray, my lord, notice may be issued, my lord, to the private respondent and this, my lord, APIC.
The information commission cannot direct my lord to file FIR, my lord.
But information commission can require the other authorities to come and to provide information to the applicant, my lord.
No,
Under which provision?
Well, Section 19, my lord.
Nineteen refers to the information available.
Yes, my lord.
Available
In that
information.
case, my lord, Section 6, my lord. Section 6, my lord. 3, my lord. Section 6, subsection 3, my lord.
Section 6.
Yes, my lord. Where an application is made to a public authority requesting for information, my lord, which is held by another public authority.
6.
6, subsection,
Yes,
subsection 3, my lord.
yes.
Yes, sir. Where an application is made to a public authority requesting for an information which is held by another public authority, or the subject matter which is more closely connected with the functionings of another public authority, the public authority to which such application is made shall transfer the application or such part of it as may be appropriate to that other public authority and inform the applicant immediately about such transfer. Provide that the transfer of an application pursuant to this subsection shall be made as soon as practical, but in no case later than 5 days from the date of receipt of the application. But the appellate authority, it is the bonded, it is the duty of the appellate authority to ensure the information is provided to the applicant. Section 3 also itself says right to information. Section 3, subject to the provision of this act, all citizens shall have right to information. Now, I have a right to information.
See, all the information referred to under the act
Yes.
is regarding the information which is available.
Right.
Here is a case where information is not available.
Actually, it must be available. Why? Because the outgoing public authority cannot take away the file.
See, yes, you are correct.
Right.
Under this kind of situation, what does this act provides?
Well, I have filed. I have filed this.
Is there anything in this act? We are not saying that the Information Commission has done anything wrong by passing that order.
My lord, please come to my prayer, my lord. Page 24.
Prayer what?
Yes, my prayer.
Huh?
A writ in the nature of mandamus, my lord. Because
who?
this is a writ petition, my lord.
Yes.
A writ in the nature of mandamus shall be issued directing the private respondent 3, my lord. Come PIO, RWD so and so, to furnish information to the petitioner as sought in his RTA application, or to direct the respondent commission. There's another part. But since this is a writ petition, my lord, this honorable court can direct the respondent number 3, my lord, to furnish information to me, my lord. If necessary, in the meanwhile, my lord, I will file, my lord, appropriate application for including, my lord,
Then commission is powerless under this act. Now, what are the judgments?
I have not brought my lord, my lord kindly issue notice that I.
No, we see issue notice is no difficulty. Under,
In these circumstances, my lord.
yes,
If he is not satisfied with the affidavit filed by the my lord, the BIO. Document, my lord, the information commission cannot direct my lord. My lord, the judgment, my lord, I have not wrote my lord. CBSE versus Aditya Bandhavatiya also, my lord, and followed in my lord 2017 SSC online Delhi, my lord, in register Supreme Court of India versus RS Mishra, my lord. I will bring those judgments, my lord. Supreme Court, second is by Delhi High Court, my lord, following the judgment of my lord, Supreme Court, my lord.
let us, what is the reference of the Supreme Court judgment?
2007, first, my lord, CBSE versus Aditya Bandhavatiya, 2011, 8 SSC, 497. It was followed in my lord, followed by.
There, this kind of,
Regarding my lord, to furnish information, my lord, but my lord, it was ultimately held that my lord, there was no such information, my lord.
okay, no
So-
such information.
So, my lord, the commission is not bound to my lord,
Ah,
direct the my lord PIO to furnish the my lord information.
then it has been said that he may file complaint against them.
My lord, it is not said by my lord, there in the judgment, but it is my submission, my lord. Because
You-
my lord,
Your submission is supported by any precedent or just?
no, because it's a clear principle of law, my lord. The affidavit has to be proved before if someone disputes the affidavit, my lord, it has to be proved before an appropriate court of law, my lord. And my lord, the commission, my lord, not acts as a judicial in a judicial forum, my lord. It acts in an administrative capacity, my lord. My lord, there is also judgment to that effect, my lord. There is 2013 10 SSC 359, my lord.
See, Mr. Saikia, at the outset, this court has made it very clear we don't find any wrong in the order of the commission. Is not it? We never said the commission should have done that, should have done this, and the order passed by the commission is wrong. We have never said that. What we are trying to get is what will be the remedy for the information seeker in such kind of a situation? In such kind of situation, if there is any within the act,
No, my lord.
and if not outside the if this respondent number 3 comes and file an affidavit
My lord.
saying that information is not available
My lord.
as he has contended before the commission,
My lord.
then what follows
My
according
lord,
to you?
This honorable court is adjudicating this matter under 226, my lord.
Hmm.
This honorable court can issue writ of mandamus also, directing the authority. If necessary, my lord, I will implement necessary parties, my lord. Directing the authorities to ensure, my lord, for providing information to the seeker, information seeker. my lord.
All right. So you have to
My lord.
build up your case in that line.
Yes, my lord.
Information Commission is not going to. Yes, what is the matter about?
But, it made a basic error, land dispute, madam, title dispute.
Land dispute between who?
Belong to agriculture department, madam. Over that, madam, this petitioner and prior respondent, madam, claiming title, madam.
Hmm.
On our part, my lord, I am appealing for respondent number 3 and 4, my lord. I have already filed my affidavit, my lord, our affidavit for department, my lord.
Can it be disposed of?
My lord, private respondent is also there, my lord. On our part, we have filed affidavit, my lord. How many pegs involved in this case, my lord?
So many?
Pegs are involved in this case, my lord. That will take time, my lord. Otherwise, on the report, my lord, land belong to agriculture department.
Manjo is appearing for whom? Manjo? You are Manjo? No. You are who?
Two,
Land
my lord.
department.
Two, my lord, respondent of two.
You are a counsel for the land department? Okay. Land department is file affidavit.
No, no.
None appears for the petitioner. Listed after 8 weeks. Yes.
Lordship, service upon two private respondents, Lordship, already been served, Lordship. Midway, Lordship, pleadings are completed. In fact, they have filed their affidavit also government side, Lordship. Matter can be hard, Lordship. Matter can be hard. Yes.
What is the matter about?
Lordship, here basically we have challenged two orders passed by the EAC, Lordship, for constituting a mail, Lordship, without authority, Lordship. Lordship is aware that after coming of AP Civil Code, they don't have the authority to constitute a mail, Lordship.
Yes.
They have exceeded their power, Lordship.
That is the only order challenge.
Order challenge, Lordship. And then they too, Lordship, upon a complaint of adultery, Lordship.
Where is that?
Lordship, we may kindly come to page 17. This is the complaint, Lordship. Lordship may kindly just see the subject, Lordship. Complaint against Mrs. Nyapi Naso. She is the petitioner here, Lordship. Yomsa on adultery. Lordship is aware that in the year 2018, Supreme Court has struck down this decriminalized for 97 already, Lordship. In case of Joseph Sain versus Union of India. Now they are coming up with this complaint, and upon this complaint, the EAC is acting upon and has issued this impugn orders, Lordship. Page 18 and 19, Lordship. Two impugn orders simultaneously, Lordship. One after another, Lordship. Constituting a mail, Lordship. And Lordship is aware that AP Civil Code, after AP Civil Code, coming of AP Civil Code, they don't have authority. That is my case. And then the two parties, Lordship, disputing parties, they are not from this jurisdiction, Lordship. They are from some other district.
What is the impugn order?
Lordship, page 18. Page 18, Lordship. Page 18, Lordship. This is mail order of 18 February 2022. Lordship.
What is mail?
Mail means kabang. Lordship. Mail, it's in Nisi dialect, Lordship.
Nisi dialect.
Lordship.
Parties are Nisi.
No, Lordship. So both of them are Galos. So why I'm saying, Lordship, they are not from this jurisdiction also. They are from West Siang district, Lordship. In fact, to that effect, I have annexed the scheduled tribe certificate and PRC of my
Have you filed affidavit?
Lordship. They have filed.
How have you justified this?
Lordship, of course, we have filed our affidavit, but to be honest, the EAC is not the competent authority to call for a mail order. Of
Have you said so?
course, we have not said in the
Okay.
affidavit.
Lordship, my humble prayer is this to impugn order has to go, Lordship.
To impugn order.
Lordship,
Which one?
page 18 and 19, Lordship.
19.
One more is there,
Okay.
10 March 2022. Subsequently, after passing of this order, another order was passed.
ESC says he is exercising power under administrative justice regulation.
It's had been amended.
It is not there. He has quoted 1954 also. Administrative Justice Regulation Act 1954, Volume 1.
Should be 45.
Had Mr. J. Jing, counsel for the petitioner, and Mr. I. Rira, learned additional senior government advocate for the state, none has appeared for the respondent number 3, despite service of notice. As indicated in Office Note dated 26/4/2023, as well as order of this court dated 29/6/2023. This petition is directed against the order dated 18 February 2022, issued by the ESC Executive Magistrate, Eternal Capital Complex, Eternal by number page 18, as well as order dated 10 March 2022, issued by the ESC Executive Magistrate, Eternal by number page 19, whereby local mayor within stroke Kewang has been constituted by the ESC Executive Magistrate, Itanagar Capital Complex, comprising of the members mentioned in the impugned order to decide marriage dispute case between the petitioner and the respondent number 3, is not it?
Lordship.
Respondent number 3. Full stop. The aforesaid impugned orders have been just a moment. Purportedly in exercise of power under Administration of Justice Regulation Act 1954 of Arunachal Pradesh, Volume 1. Also, though counter affidavit by the respondent number 2. Respondent number 2 is ESC or what?
Yes, yes, Lord.
Respondent number 2. The extraction commission in a capital complex has been filed contesting the case. Learned counsel for the petitioner as well as learned for petitioner Mr. Jain as well as learned additional senior government advocate Mr. Irera have submitted that the provision that the Administration of Justice Regulation Act 1954 of Arunachal Pradesh Volume 1 mentioned by the ESC cum Executive Magistrate Itanagar in the impugned order is incorrect. There is no Administration of Justice Regulation Act 1954, but there is a regulation called Administration no, Assam Frontier Administration of Justice Regulation 1945 and under an Arunachal Pradesh Civil Courts Act 2021. Also, the counsel for the petitioner as well as learned additional senior government advocate Mr. Irera have submitted that in neither of the provision. No, sorry, have submitted that the power to constitute such forum for resolution of a dispute between the parties by the ESC cum executive magistrate has neither been conferred under Assam Frontier Administration of Justice Regulation 1945 or in the Arunachal Pradesh Civil Courts Act 2021. In view of the above, both the impugned order dated so and so issued by so and so by so and so shall stand cost for want of jurisdiction of the respondent number 2, namely the EAC cum executive magistrate Itanagar Capital Complex Itanagar to constitute mail to Kevin for resolution of a dispute between the parties. Repetition is disputable and terms above. Yes.
Look like petitioner is not present, my lord. We have filed a rapidly in opposition, my lord, education department.
What is the matter?
It is regarding construction of engineering college, my lord. Engineering college. We started constructing this engineering college at Tolu, my lord, on the basis of this.
All right, none appears for the petitioner. And they are listed up to 6.
My lord, for this 4, I am waiting for affidavit, Parawal's reply, my lord. I have
Hmm.
written later, this recently also.
We have received his comments.
Yes, no, we are waiting for the Parawal's comment, my lord.
What is the matter about?
It is regarding, my lord, claiming of a contingency peon in lieu of land donation. My lord. Actually, the school was established in 1958, my lord, as a government primary school, and upgraded to upper primary school, middle school in 1968, my lord.
Yes, you give the counsel for the petition a place. You have encouraged upon
Sorry.
the place for the petitioner. Yes. Yes, how can you be given an appointment?
The only thing that we are challenging here is that the petitioner number 1 was removed from his service by saying that there's a constraint of fund. Quite the impugned order,
You are challenging your removal.
this continuation of his, of her service. Annexure 1. Page 18 is the type-out copy.
All right. Okay, we'll give them time to file affidavit.
Yes.
Mr. Bhutia, counsel for the petitioner, and Mr. P. Ramu, extended counsel for the education department. All the respondent who pressed for is granted further 6 weeks time to file counter affidavit. This is after 8 weeks.
Please, your lordship. Lordship, here, issue is very limited.
Hmm.
I have been, my lord, dismissed from the service. My lord, basically, 3 issues are involved, my lord. The first, the departmental inquiry committee report is not, my lord, is arbitrary and is not as per the records, my lord. And secondly, my lord, the dismissal order issued by the, my lord, the department is not, my lord, is not as per the, my lord, jurisdiction, my lord, has no authority, my lord. The impugned dismissal order has been passed by such authority who is not having the authority to, my lord, dismiss
Okay,
me from my service, my lord.
yeah, affidavits have been filed.
My affidavit is with my lord.
Okay.
So therefore, my lord, my limited period, my lord, long years back, I have been, my lord, dismissed from the service. And my lord, the affidavit filed by the state respondent is also, my lord, very limited, my lord. Only they are saying that no report, as per the report, we have dismissed from service. And my lord, the dismissal order, to that extent, my lord, they are not disputing, my lord,
Hmm.
from the records, my lord. So therefore, my lord, the dismissal order, even if it is to be passed, my lord, has to be passed by the authority who is having the jurisdiction, my lord, authority to, my lord, dismiss me from service, my lord. So therefore, my lord, on 3 counts, my lord, I'm before your lordship. First is, my lord, I'm not alone, my lord, for escaping of the, my lord, the UTPs from the, my lord, jail. There were so many of the staffs and so many officers who is, my lord, above me also, my lord. And the departmental inquiry report is not as per the, my lord, the record. Only, my lord, all 3 officers were charged. And out of 3, my lord, 2 has been, my lord, already, my lord,
Okay, we'll proceed for hearing.
Yes,
so that this is the, my lord, my friend, my lord, on Monday, my lord, matter may be disposed.
This
Since,
such matter cannot be disposed of at a motion, sorry, admission stage.
my lord.
Has to be heard.
matter may be-
There was a DP, departmental proceeding.
Yes, ma'am. As per the departmental proceeding, my lord, this order, my service, my lord, the dismissal order has been passed by the authority who is not having authority, my lord.
Did you file an appeal?
Yes, my lord.
Appeal has also been rejected.
Rejected, my lord, by authority who is not having the, my lord, jurisdiction.
Okay.
So therefore, my lord, the constable, my lord, my service has been removed, dismissed from, dismissed in the year 2015. So therefore, my lord, at this stage, my lord, I'm almost suffering, my lord. And my wife is also suffering from cancer and livelihood of my lord.
Mr. You are pressing for disposal of this case. In so many cases, we find that you're not attending where we find that the matter can be disposed of also.
Well, in other cases, I am
You are
regularly attending.
you are selectively pressing the matter.
Well, there are certain cases which there is some urgency in the matter.
Had Mr. M. Katul and Council for the Petitioner and Ms. P. Pano, Government Advocate. Representing all the respondents.
Yes, your lordship, 1 to 8.
All the respondents. And Council for the parties, the pleadings have been exchanged. Yes. Issue rule. Says the parties are represented, no precise steps be taken. Will list it for hearing in due course.
Well, after 2 weeks.
Huh?
After 2.
It will come in its time.
Well, okay, let's see.
My lord, in this matter, affidavit is filed by an unauthorized person who is not party in the case.
Government.
Yes, ma'am. Affidavit is filed by district land revenue and settlement officer who is not party in the petition.
Is it correct, Ms. Sangeeta?
Yes, your lordship, I'm sorry to inform your lordship that there's a clerical mistake in our application by not mentioning that I'm authorized to file this affidavit.
Affidavit is filed by whom?
Dealer research. But it was supposed to be filed by DC, your lordship. In other cases, your lordship, dealer also they used to file on behalf of DC, your lordship.
If he is authorized, then.
But
he
your lordship,
can-
there is an authorization letter.
Dealer is not a party.
Not party.
May please, question. I beg to pray that 1 week time may be granted so that we can correct the
For what?
this clerical mistake.
Clerical mistake means?
Uh, In our affidavit, your lordship, in paragraph 1,
The dealer was authorized by Deputy Commissioner.
other cases, yes. In this case also, he have been authorized, but by mistake, they have omitted to mention that he had been authorized by the DC. But authorization letter is with us.
No, affidavit is neither mentioned that he was authorized nor authority letter is enclosed. Let the proper affidavit.
Will
Okay, had Mr. D. Ladi, Ladi Council for the Petition, and Ms. P. Sangeeta, Ladi Government Advocate, who submits that the counter affidavit by the respondent was inadvertently filed by the authority who is not a party in the initial petition for his request for and is granted 2 weeks time to file a counter affidavit by the respondent. Okay.
Interim order, my lord.
Interim order pass areas will continue till the next level listing. Listing up to 2 weeks,
Most of them.
3 weeks.
Hello.
Yes.
Here, Lordship, I'm appearing on item number 35.
Item 35,
This is regarding non-payment of pension.
non-payment of
Pension.
on what ground?
Lordship, initially, they have taken the ground that there was no NOC or vigilance clearance. Lordship.
Ha,
But after filing of this writ petition, now they are taking another ground. Lordship. Now they are saying that the petitioner was drawing excess salary. So after recovery of the excess salary, this pension case will be settled.
okay. Then this this writ petition does not pertain to denial of a pension for want of NOC.
No, it was
Initially it was,
initially it was.
now it has changed.
Yes, sir. After filing of this writ petition, Lordship.
Huh?
After filing of the writ petition, Lordship.
Writ petition.
Yes, Lordship.
After filing of this writ petition, they are
Okay.
taking this ground.
Then what do you propose to do with your writ petition?
Lordship, it is a settled position of law, Lordship, that excess payment of salary after the retirement of employee, Lordship, it cannot be recovered, Lordship. This is a settled position of law.
Okay, that means it will require some hearing. Is not it?
It may be disposed of. With a direction to the respondent authorities to release the pension immediately, Lordship. Because Lordship, here petitioner was retired in the year 2019, Lordship.
Ah,
Since then, he has been deprived of his pension, Lordship. And Lordship, this is the second round of litigation.
no, I have not understood. Initially, you have not yet been paid pension.
No, not yet, Lordship.
Your pension has not been settled yet.
Not yet, Lordship.
So initially, it was on the ground of,
Want of
Absence-
NOC and.
yes,
LS clearance.
for want of NOC.
Yes, Lordship.
Now that has become what now?
Now, Lordship, they are, after filing of this writ petition, Lordship, they are taking another ground, Lordship.
In their counter affidavit.
No, they have not come up with affidavit, Lordship. They have just produced a letter, Lordship, last occasion, Lordship.
Ah,
And in their letter, they are saying that the petitioner was drawing excess salary. So after recovery of the excess salary, his pension case will be settled, Lordship. They are saying this, last
Ah.
occasion, Lordship.
okay. Which according to you is not permissible.
Yes, Lordship.
Why it is not permissible?
Because, Lordship, it is a settled position of law, Lordship. Lordship, I'll be relying on a
How
judgment.
much excess salary you have drawn?
That I have not idea, Lordship.
They have filed affidavit.
Not yet, Lordship.
Then affidavit will be required. Is not it?
Yes, Lordship, but law is clear, Lordship. Excess salary cannot be recovered after
So where do
that.
you say that they are denying your pension on the basis of
Because,
excess payment made?
because, Lordship, they have produced a letter, Lordship, last occasion, Lordship.
Who has produced?
The London government advocate, Lordship.
Okay. Who had been tapping?
Lordship, my colleague was doing in this case, Lordship. Yeah, I think we need to file our affidavit.
Item number 35.
35.
Okay. 35 is out.
Lordship,
Let us
on last.
take up serially. Yours is the last item. We will begin with 27.
37. Lordship, I instructed my staff to sort out all the Lordship cases which are connected to pension law. I have checked up Lordship, matters are almost, they are connected to pension. But so far the subject is Lordship,
See.
NOC.
Your staff doesn't have a law background. They will not know. They will not be able to distinguish and identify.
No.
Ah, that's all.
Here only the item number 27 has its own Lordship case. It's pertaining to the non-founding of NOC law.
Ah.
The rest are on their own merits.
So that's what I ask you. Why have you furnished this?
Lordship, all are since pension matter also.
We never asked to furnish you all the matters, all the pending matters which pertains to pension. We can only say the NOC part.
I'm sorry. Lordship.
We started with Miss T. Wangmo. Then you came in. And the result is this.
No other cases are pending also.
Your office seems to be highly disorganized. Whereas we have a lot of government advocates. So NOC is only this case,
This case,
27,
27.
unnecessarily listed. Yes,
Item 27 can be disposed of and rest may be listed on their own process. Town also.
Where is? Yes, what is 27?
27 also, since there was an encroachment also, so NOC was not furnished.
Yes, when did the petitioner retire?
My lord, the petitioner has retired on 39/2022, your lordship. 39/2022,
30 September
30 September, your lordship.
2022.
2022,
From which post?
from the post of principal, Government College, Bomdila.
Huh?
From the post of principal, Government College, Bomdila.
Principal Government College, Bomdila. And why your pension paper has not been finalized? Why your,
On the ground that the petitioner occupied a plot of government land, your lordship.
what is that? Any order?
25/2/2022, your lordship. That will be an extra. Six, your lordship.
Hmm?
An extra 6.
Annexus 6, page number. Oh, that is that notification.
Yes, your lordship. An extra 5 is the order
Oh,
regarding NOC.
all right. With reference to.
Look,
Ms. D. Tamuk Lanet, counsel for the petitioner, and Ms. S. Tapin Lanet, senior government advocate representing all the respondents. The petitioner who had retired from service on attaining the age of superannuation on 39/2022. While working as principal Government College, Bomdila, has filed this petition raising a grievance against the respondent authorities for not finalizing his pension papers. Full stop. According to the petitioner, his pension papers have not been finalized. The petitioner has not been paid pension. Because of the letter dated 10 August 2022, written to him by the DLRSO for Deputy Commissioner West Kamen District, Bomdila, by number so and so, at page 29, whereby it has been stated that the petitioner has encroached upon the government land and constructed a RCC building thereon. And as per government order number VIG-71/2014/365 dated 25th February 2020, issued by the Department of Vigilance, Government of Andhra Pradesh, Itanagar. No objection certificate is required to be. No objection certificate regarding non-encroachment of government land is required to be submitted for finalizing the pension papers of the petitioner. Full stop. The respondents had filed counter affidavit. Counter affidavit filed, na? You know,
No, right.
Supporting the letter dated 10 August 2022, written to the petitioner by the DLRSO for DC, West Kamenur District, Bomdila, where the reason for denying the pension of the petitioner has been stated. Also, since the entitlement of the petitioner, since it is a settled position of law that pension of a retired employee cannot be denied on the basis of an executive order such as the order mentioned herein above, dated 25th February 2020, issued by the Department of Business, Government of Andhra Pradesh. Unless the same is in accordance with the provisions of the rules that govern the entitlement of the pension of the retired employee, which in the instant case is stated to be Central Civil Service Pension Rules 1972. 1972. This writ petition is hereby disposed of with a direction to the respondent authorities to immediately finalize the pension papers of the petitioner and pay to the petitioner the pension the petitioner is entitled to in terms of Central Civil Service Pension Rules 1972, without insisting for NOC as per order number so and so, vigilance so and so, dated 25th February 2020, issued by the Department of Vigilance, Government of Andhra Pradesh. Petition is disposed of with the above direction. Here you write one thing before that. Though this in the above, though this writ petition was directed to be listed along with the writ petitions mentioned in the order dated. Though this writ petition was directed to be listed along with WPC 167 of 18. 211 AP of 19, 17 AP of 21, 271 AP of 22, 411 AP of 2022, 72 of 2023, 233 and 233 of 2023 by the order dated 31/7/2023. Since all the writ petitions mentioned herein above is found to be not analogous to this writ petition, the instant writ petition is taken up for disposal separately.
So far, LOC and clearance of two partners. One is the vigilance clearance, other one is LOC and the Deputy Commissioner.
NOC regarding non-encroachment of government premises.
Is LOC that, and observation, LOC without insisting NOC. It may be clear to the Deputy Commissioner.
And I said NOC in terms of this vigilance. The reason is this. Page 29. You say that 25th February 2020 notification you are referring to.
Is
Is there any vigilance case pending against you?
Oh, your lordship, I am not aware of it.
Huh?
No, your lordship, no vigilance.
because this order touching both the LOC clearance. NOC from Deputy Commissioner and vigilance clearance. LOC.
What is page 30?
This is LOC,
This is a Indian
issuance of vigilance clearance.
Oh, vigilance clearance.
And it includes the NOC from the Deputy Commissioner.
Oh,
If there's any enforcement losses, Deputy Commissioner has to punish the NOC. Basing on that, vigilance has to be, vigilance clearance has to be given by the vigilance department.
okay.
Also by after examination, if any other case also.
Then what will say is without insisting for NOC
On the Deputy.
and the NOC regarding non-encroachment of government land from the deputy commissioner.
That will be.
From the deputy commissioner in terms of on order number VIG etc. 25 February 2020.
That will be.
Then all this will be listed. Yes, 2028.
There is already an order for lifting the matter for hearing.
Hmm?
There is an already order for.
Hearing, huh?
For hearing.
Okay,
So all these cases may be listed in their own.
okay, then you pass like this. Then you write item 28 to 35. These writ petitions have been listed today in pursuant to order dated 31, I think, huh? Passed in WPC 323/2022. Also, upon perusal of the records, it has been found that all these writ petitions are not connected to WPC 323/2022. In view of the above, let all these writ petitions be listed in due course. हाँ, secretary, हाँ, secretary. रवि को बुला. Yes.
The government reject to file the affidavit money.
There appears to be so many private respondents.
Yes, my lord.
All of them have been served. Notice.
Yes, my lord. Yes, my lord, the notice has been served, my lord.
Are you sure? Yes, you wanted to say something.
Yes, your lordship, I'm appearing for respondent number 1,
Ah,
chief secretary.
respondent 1.
1. I beg to pay for 2 weeks, granting of 2 weeks time for.
Have you received instruction?
No, your worship, for that, your worship.
All that will resume after 5 minutes. Huh?
Yes, of last month.
All of the step has been taken to order private respondent. But from the office record, it's revealed that many of them answered. So my lord, in such situation having I'll prepare for fresh system.
You will take this step.
But I have gone through the my lord record. And there is maximum answer.
Okay. Mr. In view of the office note dated 1/8/2023, Mr. C. Modi, counsel for the petitioner, press for and is granted 2 weeks time to take press steps for service of notice upon the respondents mentioned therein. Released it after 8 weeks. So many respondents.
But
My lord, we have to file affidavit in opposition. But,
You are for the respondent.
yes,
Which respondent?
CVSC.
CVSC. What is the matter of?
Matter is about correction of date of birth of the petitioner.
You have put a petition.
Yes. Lordship, this matter is in process now, so kindly dispose of this matter.
Okay. Your name?
Tado Siga.
Your name is not there in the cause list. Okay, Tado Siba.
T Siga, sir.
T
Siga.
Siga.
Yes. SIGA.
Okay. Mr. T Siga, petitioner. Mr. T Jamo. Standing counsel for the education department.
report.
2, 3, and 4. Before that, Mr.
B. Kamdak
B. Kamda.
for CVSC.
Counsel for the respondent number 1, CVSC. Mr. Siga, learning counsel for the petitioner has submitted the writ petition has become infractor. In the event submissions made, writ petition is dismissed as infractor.
Mobilize.
Please, Your Lordship, my lord, the office note shows that we had not taken steps on respondent number 5. Your Lordship. However, we had already taken the steps, Your Lordship. It seems there has been some miscommunication.
What is the matter about?
My lord, the petitioner is challenging the order of the the order of the assistant commissioner, Your Lordship, extra assistant commissioner in issuing order, Your Lordship, for conducting of mail, Your Lordship. And the petitioner is
For direction of
conducting of mail, Your Lordship.
mail.
Yes, Your Lordship. The petitioner is also challenging the mail decision, Your Lordship.
On what ground?
On that, the EAC could not have issued the parent orders, Your Lordship.
Okay, what is that
That's
order?
not jurisdiction.
What is that order?
My lord, it is at annexure 4 and 5, Your Lordship. Page number 41.
Oh, respondent 5 has not been served.
Yes, Your Lordship, but we have already taken the steps, Your Lordship. On earlier occasion also, we already have taken once, you know.
Parking Talon,
Yes, your lordship.
D sector,
Yes, your lordship.
POPS Nalagan. Parking Talon is an employee of this registry,
Yes, your lordship.
huh?
Yes, your lordship.
Then you should have given the proper address.
Yes, we did not wanted to give the address of this Honorable High Court, your lordship, that is why. We
Ah.
thought it would be proper to give the,
What is there in giving a proper description and status of a person?
we thought that it would have been proper if we had given the proper home addresses. instead
Okay,
of-
does you take dusty service? All right. In view of the office note dated 1/8/2023, Mr. Tamuglanut Council for the petitioner seeks leave of this court to take dusty service on respondent number 5. Leave so called is granted. Learned counsel for the petitioner. Serve notice upon respondent number 5 by Dusty. Whereafter an affidavit to that effect shall be filed. Listed after 3 weeks.
Which here, private restaurant has to file their objection on it. Their affidavit.
Hmm?
Private restaurant number 500 is represented by T buyer. He has to file their affidavit in opposition. On the last occasion, they appeared.
Respondent number 5.
Yes.
Last occasion they had appeared.
Yes, they are appearing, they have filed their local law.
All right. Their name has been shown.
Yes.
Okay. Yeah, what is to be done today?
Uh,
They have not yet filed local,
Not- not
sorry,
yet. Affidavit.
affidavit.
Yes.
We'll give them some more time.
Yes,
What is the matter about?
this is regarding demarcation of land,
Demarcation of the
land by the executive magistrate.
huh?
Executive magistrate.
Executive magistrate.
Yes, ma'am.
How the executive magistrate will demarcate? the
Yes,
land?
ma'am. We say he cannot. It is the land revenue and settlement officer,
Okay.
as per the act.
Mr. V. Pishal, petitioner. Ms. P. Sangita, you have filed affidavit?
Yes.
Along with government advocate
Up to 3 and
for respondent number 3 and 4, who submitted a counter affidavit, the respondent number 3 and 4. Have been filed non-abuse for the respondent 1, 2, and 5. In view of the above, list it again after 6 weeks.
Man. Entry may be continued.
Interim order parcel shall continue till the next date of listing. Yes.
I'm sorry to interrupt you, lordship. In item number 13, the lordship, there is an interim order.
13. Interim order pass earlier shall continue till the next date of listing.
My lord, analogous matter is pending before the Honorable Apex Court. So
What is the matter about?
this is the matter is about challenging the order passed by the State Information Commission, wherein State Information Commission has directed to furnish information documents to the information seeker.
So then what is wrong with that?
So the herein the information and documents sought by the private respondent comes under the purview of section 81J exempted under the
Okay, what information was directed to be furnished?
Information sought by the private respondents.
What was sought by the private respondent?
uh, In three part, it was sought copy of contractor registration certificate. For third, class 3 registration certificate of the petitioner. And also class 2 registration certificate and class 1 certificate.
There are other writ petitions pending.
Yes.
What is the number of the writ petition?
This is the number exactly, I don't remember. Because the same similar matter was challenged before this honorable court, but this honorable court also appealed to by the order of the RTA Commission. So the petitioners along with the instant petitioner along with other petitioner has challenged before the honorable apex court, wherein the matter had been stayed.
Yes. Are you there, Wangmo? No.
I am for only respondent number 4 months.
Yes, you have any idea what is going on here? No, no idea.
No, ma'am.
He has referred to Supreme Court also. And he has referred to some other writ petitions pending before this court. You don't know anything of, you have no idea what is going on around you.
Yes, I think one matter which I also appeared.
Yes.
The Indian matter and we got Supreme Court. There is a mistake.
That writ petition is pending here.
And
Do you have the number? You have the writ petition? Okay, okay. Let us point out to you for this. We'll direct this writ petition along with the petition.
Here, WPC 231, my lord. Respondent, my lord. Union of India has to file their affidavit.
What is 309?
309 is with regard to non-payment of solution, my lord.
Okay.
And 231 is for non-payment of compensation for value of land and solution.
All right. But the same person,
Same land, my lord.
same land.
Yes. They have paid compensation for the properties, house property and crossing, but not paid any. compensation.
Affidavits have been filed.
Well, here in WPC number 231, one of the CGC, the government of India, one of Union of India has to file their affidavit. One.
Government of India is filed affidavit.
One of, they say they will not be filing, my lord.
Okay.
309 we have filed affidavit and said that we forward in 231.
Okay. Then
This-
what is-
This may be recorded, my lord.
What is to be done?
Then matter may be fixed for admission hearing. my lord. They say, my lord, the affidavit filed in 309 would cover the affidavit for the writ petition number 231.
All others have filed affidavit.
Yes, one of the secretary land management, my lord. Will rely on the affidavit. But
Filed by the,
equally good.
okay, deputy commissioner is filed. In both the writ petition,
Yes.
deputy commissioner is
Yes,
filed.
yes, yes.
Parties are the same, I think.
Yes, but same.
Mr. B. Pitcher, Learned Counsel for the petitioner. Mr. N. Sora, Learned Counsel for the, huh?
On behalf of
On behalf of M. Kato, Learned DSGY. Where is Kato?
My lord, you need the court premises due to some personal.
Okay. Representing respondent 1, 2,
1 and 2.
1 and 2. They come to for 3. 3 SW for 4, 5, 6. Mr. Sora, Honorary Council, has submitted that the Union of India has filed counter affidavit in WPC 309 AP of 2020, which affidavit will also be relied on by the Union of India in WPC 231 of 2022. Full stop. Mr. Kamluk will nominate standing counsel for the LM, representing respondent number 3, submits that respondent number 3 will rely on the affidavit filed by respondent number 4.
Yes.
The deputy commissioner from the person. Mr. Tapin Ran Senior Governor Advocate submits the counter affidavit by deputy commissioner. By the respondent number 4, the deputy commissioner has been filed, which will also cover the extent of the respondent number 5 and 6 as well. Is not it?
Sure.
Also, in that way of the purpose. You will file, you will not file any reply.
No.
Also, Mr. Pichar and counsel for the petitioner submits that no reply to the counter affidavits filed by the respondents is necessary. Also, in view of the above, it appears that the pleadings have been exchanged by the parties. Accordingly, let this writ petition will be set for admission hearing after
3
for
weeks.
3 weeks. Okay, 3 weeks.
My lord, in the earlier item number 16, I forgot to mention there is an interim order.
Okay, interim order pass, yes, continue till the next.
Most of them.
Yes.
Here, Your Lordship, we have filed affidavit on behalf of 2 and 3, and on behalf of 4,
Yes. What is the matter about?
pending salary, payment
Hmm?
of salary.
Salary.
Salary of the petitioner has been withheld for a period of 2 years.
2 years. By whom? By which
By
respondent?
the Directorate of Horticulture.
Hmm. Horticulture has filed affidavit,
Yes, 2 and 3 have filed, Your Lordship.
2 and 3.
Yes.
Secretary and Director of Horticulture. has-
Any more affidavit is required?
Yes, one more, Your Lordship.
By
The-
whom?
The
Deputy Director.
Deputy Director.
of the
Okay,
law.
horticulture. Have you received instruction?
Yes, it's ready, Your Lordship. By Monday we'll file.
Okay. Ms. T. Y. Bhutia, account petitioner, and Ms. Y. Rera, learned common advocate, representing all the respondents who submits that the counter affidavit by the respondent 2 and 3 have been filed, and counter affidavit by respondent 4 is ready, and the same shall be filed by Monday. And Monday means we give the date. In view of that this petition will be stay after 2 weeks.
Apply. Yeah, Your Lordship, we have filed our affidavit, Your Lordship.
Yeah. What is the matter about?
Your Lordship, the
Is pertaining to eviction.
Eviction,
Yes.
infractions or what?
That I don't have any idea.
Which, because
No, your lordship, it's about,
What is the where is the impugn order?
it is, basically, your lordship, the petition is praying for, to, release any alternate allotment instead of this already existing allotment. government lots.
You have filed affidavit.
Yes, your lordship.
What do you say about the alternative development?
In our affidavit, we are saying, your lordship, that there is no such any vacant land. That is, the petitioner is claiming to allot him.
Okay. You will file affidavit?
No,
You will, okay. None appears for the petitioner. Mr. Mr. D come look for one. Where you run for?
To your lordship.
Two. Okay.
Private respondent is also there, your lordship.
So, yeah. I think we can dispose it though. Is not it? Why is he is, why the petitioner is asking for an alternative plot of land?
Because it's the contention of petitioner that the private respondent he has blocked his entrance, his right of way.
Approach. Okay. Mr. Herrera, along with counsel for the respondent to summons that the counter affidavit, but the respondent two has been filed. Mr. Kamal and the single summons that respondent number one will not file a counter affidavit and will rely on the stand taken by the respondent number two in the counter affidavit file. It appears. No, obviously dated 1/8/2023 indicates that respondent number three is yet to be served. Also. In view of the non-representation of the petitioner listed up to 8 weeks. Yeah.
Your Lordship, we have received this report in original last night only, my lord.
Why the record was called for?
Your Lordship directed me to bring this record in original, my lord. And actually, I was required to file affidavit in opposition also, my lord, but the record being transmitted to me last night, my lord. I cannot prepare affidavit in opposition. I can prepare it, my lord. Instruction has also come in written, my lord. I can prepare it by the night, my lord.
Just a moment. What is the matter about?
It is about, my lord, the appointment of this engagement of coordinator in residential schools, my lord. Coordinators in residential schools, and coordinator residential schools is not a substantive post, my lord.
Okay.
And their substantive post and their this status and condition of service has not been affected by the country order. They are, my lord.
Have you taken dusty service? You are challenging what?
Impugn order is.
Transfer order, no?
Transfer order,
Where is that?
page 51.
Page 51. JT,
Yes,
posted as academic health hygiene.
my lord.
He is relieved from coordinator, residential school.
And directed to examine the charge of innovation. Or he is directed to hand over the charge.
You were a coordinator,
Coordinator,
residential school.
residential.
What is your contention? That PRT is a assistant teacher,
Assistant teacher, primary teacher.
primary teacher. JT is a junior teacher. Primary teachers are not eligible to be
Uh,
something like that, contention.
in the 9th executive meeting, my lord,
Ah,
that was made eligible. Otherwise, as
eligible, it was made eligible.
they were made eligible, subject to the condition that the teacher should be possess BEd or diploma in elementary.
Okay, where is that? Page 24,
Page 24, correct, my lord.
close 12.
12, my lord.
This is approved. Teachers are sound academic, only. Different intervention from teachers with, so there is no classification of teachers now. It's not a PRT can also be,
Correct, my lord.
but they will have to have a 10 years teaching experience with BEd.
BEd, my lord,
Okay.
or diploma in elementary.
Education would be, okay. So your allegation was that he is not a BEd degree holder.
He is not a BEd degree holder. And then, my lord, this private respondent number 5 come the official respondent number 3, the DDAC, Deed and DDAC, the origin. He had been in litigation before this honorable committee. And accordingly, when his writ petition it was allowed, he happened to join on 3rd July 2023 at afternoon. That is not disputed, that's because that is reflected in the order sheet also, writ appeal letter. Thereafter, immediately on 4th, even without perusing the record, he directly issued this impugned order.
No, just a moment. You are referring to some RTI information,
That we have filed in additional affidavit.
additional affidavit. Page number,
Page number 4.
yes. This is.
Here in this same person, that is Pokhtar Rima, Deputy Director of School Education, Daporizha. Now he is giving information saying that
There's no BEd.
there is no BEd or diploma in elementary education certificate in the service personal file in respect of Sri Tapor Garam, PRT of this establishment.
It was to ascertain that perhaps this record was called for.
My lord, this, in fact, I have asked them, his BEd is not reflected in his service book, my lord. BEd degree is not reflected in service book, which is in the Daporizha, my lord. But his BEd has been, permission to pursue BEd education was granted by us from Director of Elementary Education, and he accordingly completed and updated in Directorate Elementary Education, my lord. And it is.
When was it?
That is very much in the record, my lord.
When was it?
Possible finding the activity filed by the respondent.
It is in file also, my, in my, in the record.
Just give the date. When did you complete your when did you complete the B degree and when it was updated in the service record? Maintained. Service record is maintained in the directorate or?
No, they are in district
Service
level,
record.
wherever he is posted. my lord.
DDSC is the custodian of those documents. I don't know, my lord, by filing the affidavit in opposition, kindly come to page. In their affidavit in opposition, kindly come to page 22. This is very interesting. The same person, that is Deed and DDSC, Pokhtar Rima, issued another certificate to whom it may concern.
22.
22.
of the affidavit filed by respondent number 4.
My lord. Now, our RTI information is also of 14/7/2023, and it seems their certificate is also of 14/7/2023, wherein he has stated the undersigned is hereby certified that Sri Tapur Garam PRT is possessing B.Ed certificate from Teacher Training College, Alo West Siang District, Arunachal Pradesh. He passed the B.Ed in the year 2017 by registration number so and so, bearing roll number so and so. He has taken permission from the competent authority for pursuing B.Ed degree by number so and so, dated Itanagar 27 August 2015. His provisional seniority list is maintaining at serial number 580, which reflect his qualification, is available in the official website so and so of the Director of Elementary Education, Government of Arunachal Pradesh, Itanagar. All the official corresponding related to his B.Ed degree is available at the Office of Director of Elementary Education, Government of Arunachal Pradesh, Itanagar. Now, this person who is certifying that the private respondent is having B.Ed is the knowledge that he is certifying from the Office of Director Elementary Education.
This record is from where?
Dapo, my lord. DDSE, my lord. DDSE.
He is what? Certifying from?
DDSE.
Yes, sir.
Dapo.
What did you say?
This certification, my lord, this DDSE Dapo region certifying that this private respondent number 4 is having B.Ed certificate record there in the Director Elementary Education, whereas he is the custodian of service book of this private respondent as a DDSE Dapo region, wherein his document is not there. And my lord may kindly take a note of. DDSE is the custodian of service record book of this private respondent number 4.
Yes.
Not the Director Elementary Education. And if that document itself, B.Ed certificate itself, my lord, it was not available in the service record, then how do he issued the interim order immediately after joining on 3rd July on 4th itself? Had there been no any malafide intention?
My lord, page 2C shows the application made by the private respondent, my lord, 2C.
To see.
My lord. That shows the application made by the private respondent for engagement of this residential school coordinator.
To see means?
Yes, 2C, last, my lord, last for department.
1C.
My lord.
2C, yes,
Yes.
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 Prayer for engagement with residential school coordinator.
That is updated, my lord.
3rd
July.
July.
On the same day it was considered. 3rd July afternoon, he joined as DDSE Dapo region.
No, we are concerned with his degree. Isn't it? Yeah.
Well, now regarding this degree also, my lord, this is very interesting to note. So,
Just a moment. You have not brought the service book of.
No, my lord, he has filed it, my lord.
Huh?
Yes.
originally it was asked.
No, service book original was not asked, my lord. I was asked for this record, my lord.
What record?
This record, original record.
Original record of what?
That the one you receive,
This record contains what? This record, what do you want to show from here?
There find nothing in application, my lord.
My lord. That this respondent number 4 is a BE degree holder?
My lord.
Where? Which one?
Uh,
You flag the relevant part. Let us see.
I have the index, my lord. Page 3C, my lord.
See, this is not an original record. This is record you just build up. Anyway, let us see. I think the qualification, the educational qualification, all the particulars of an employee contains in the service book.
Definitely, my lord.
And all update is made in the service book.
My lord.
My lord.
Where from these loose sheets you have brought?
My lord,
Anyway, let us see.
my lord, in fact, there has been this the error in updating, my lord, I think. It is updated here, my lord, but this updating in DEE, he has been updating, my lord. He
Who-
is
who is the authority to, who is the custodian of service book of this employee?
DDSE, my lord.
DDSE.
Yes,
So we will not ask anything from directorate,
my lord,
is not it?
my lord.
We would like to, any document has to be from the custodian of service book of the petitioner or the respondent. Let us see.
No, my lord, in fact, it is what we have in our this website, my lord, and it is very much in our record. So we have printed out the relevant record, my lord, relevant page. Even in his seniority list, we have updated. He is now MA BEd, my lord. Of course, not in service book, my lord. Service book should have been updated, but that is of course not the fault of this private respondent, my lord. That will be my fault, my lord. My department's fault. We should have updated. When we have sent him for this further education, further study, and he completed and submitted his completion report and degrees, we ought to have submitted this updated, my lord, even in his service book. That has been inadvertently missed out, my lord. But it is a fact, my lord. I also have personally checked, my lord. Even his this fact, this document is true, my lord. It is still in the website, my lord. His BEd was pursued, cleared on the force of our permission only, my lord.
Yes, Gaurav, we are staying the transfer order. It is not your fault. That is the fault of the office. By looking at the records, I'll say this is not a record. Let the original record be produced.
I'm already started working in as a coordinator.
No issue, no issue. Yes.
Let me just make a submission for a few minutes, Lordship. Lordship, the entire allegation which has been made in the petition also, in the red petition also, that the mala has been committed by the respondent in Book 5. But there is not even a single mention in the entire red petition to substantiate his allegation.
No, let the authority produce the original record containing your all particulars. Can't give in this form. If we from the record we find that yes, you have done your BE, is not it? On a date which they are indicating it, then we'll say you are qualified. Then
Affidavit on court, I have already filed before this order. By stating that since I have completed my BEd also and master in ML political science also. Now,
see, you are saying we will not do. Both of you are the employee of JAMO. It is the JAMO's document which will determine. Now, what he has done is one RTA information supplied to somebody saying that you don't have a BE, same day, is not it? 14 July. And again, another on the same day, he is giving a certificate that you have a BE degree, and that he is certifying it from the record of the directorate, from the directorate while he is sitting in Daporizha. Now, a record which he has produced is a collection of some loose sheets from here and there. That's not the original. Let your service book come. Yes, you may submit, yes.
Also, even if it's not, just for the, not for the admitting the fact, even for assuming that also, I'm not qualified for the post of coordinator. But how, I fail to understand that what locus has been enforceable rights has been obtained by the petitioner. Because this is not a cadre post also in the Department of Education. This is just an attachment also.
Neither it is your cadre post.
Exactly. Also.
There is no fault on your part, neither on their part. It is we would like to see the correct records.
Also.
We are not finding any fault on you. We would like to see the correct records from the custodian of the records.
Also, in
That is the
case-
DDS.
In that case, also, if the interim order passes, it will create a mess in the department. So my humble submission also, let this matter be fixed after 2 or 3 days. In the meantime, let them file like all the records.
Can you-
Yes, also.
Can you produce the record tomorrow?
From.
See, Mister, you have to appreciate. We can't devote this much of time in this kind of a litigation. 12/7/2023, it was taken up. 17/7/2023, it was taken up. 26/7/2023, it was taken up. Why no interim order was passed? Only for the purpose of disposing of this matter on this day. Then he was asked to file affidavit as well as produce the relevant records. This is not a record. So under the circumstance, we can't see. We have to attend to the other case also.
Exactly. Also, I'm not deeply understand what the lawsuit has tried to work it out. But the fact is that also, as per the direction given by the Honorable Court, I have filed my on all lawsuits. If any documents which is found to be false also, I will be prosecuted under the criminal law also. That is only the fact that whether I have possessed the degree or not.
I'll record your submission. They have to update it.
Not updated. What happened was,
Right.
in the year 2008, I have been appointed as a. And according to the year 2015, where I took the permission from the Convener Authority to pursue my PA process. And in the 2017, I have completed my PA. In the
See,
meantime,
we have no reason to disbelieve you. Neither we have any reason to disbelieve the petitioner. Now, when there are conflicting facts presented by the petitioner and by the private respondent. Now, on what yardstick this court will judge? From the record of the custodian of the original records, DDSC. DDSC is acting in this manner. What can this court do? We have no reasons to disbelieve you. You may have done it. And neither we have reasons to disbelieve the petitioner.
But not since I have raised the question of maintainability also, so that there is no locus has been, no right has been violated by the respondent authority also. Because it has.
See, his allegation is you are not qualified to be there. You are saying you are qualified. But respondents are not, the state authorities have not been able to show whether you are in fact qualified or not. That is what we would like to say. That is what we would like to see.
Also, I have annexed the documents in the affidavit also. From the official website also.
So you want to say that your documents should be believed and the document annexed by the petitioner should not be believed.
I'm not saying that person. I'm not saying that person.
And your master, not only your master, his master also is acting in this manner. What can we do? We have to intervene.
Also, in that case, Lordship, at least I should not be suffered Lordship on the petition which has been filed by the petitioner Lordship, which is not even maintainable at all.
Why it is not maintainable? He was working in your post.
Lordship, that is only the attachment Lordship.
You are also. So both of you go back to PRT and TGT. Teaching is a noble job.
And Lordship,
Okay.
the rules which has been cited.
See, there was a decision also. Are they maths teacher? No. Why you are engaging the teachers in an administrative matter? They are good teachers. Let them teach. There was a decision also. Is not it? So that the academic interest of the students in the schools does not suffer. All teachers will not, will henceforth not be engaged in an administrative matter. There's decision also.
Now, Lordship, according to the Lordship, the issue which has been lost recorded in the last year, the performance of the entire district Lordship, it has been deteriorated. That is why the respondent authority has took the decision so that the petitioner will look after the health and hygiene process. That is to look after the entire school monitoring system. Only the certain part which has been which was attached to the petitioner Lordship, it has been given the responsibility to the respondent. That is me Lordship. That is the only part. Now, Lordship, in the last, I do not remember of the one litigation Lordship, which was pending before this.
Can you produce the record next week?
Yes, correct.
Huh? Let them produce now.
Meantime, my lord, because even if this order is stayed, this is not going to affect in any manner to the private respondents. As himself is saying that this is not a either post. So he will be not affected in terms of his salary.
See, I don't know what is there in this, what is called coordinator. Coordinator. He also wants to be very much as coordinator. Only thing is, I don't know what is there in the coordinator.
Coordinator, some experience is required for that I possess that. And
That experience also I have also explained my petition, in my affidavit also. Since I have been experienced also. Holding that.
See, who is disbelieving you, mister? Huh? You are protecting the state. Huh? And
Anyway, last time given to the respondent.
1 week.
see, we are principally against listing of a case in such a short interval. We have given so much opportunity. Why no interest? See, order which I am proposing to pass today, I could have passed on the first day, second day. 1, 2, 3. But see, your master's work. It is neither fault of Mr. Jamo. It is the department who is at fault. So I pass order, it's still the order.
Last opportunity we will give the respondent. At least. And that, your lordship will dispose the entire petition.
Dispose of the entire petition. I will produce the record, my lord.
When?
My lord, 10th, my lord.
10th.
Yes.
Okay.
Then my lord, I'll be having problem on it. 9.
9.
Yes,
Okay.
Original service book.
As brought forward by Mr. T. Jamo, Understanding Council for the Education Department listed on 9th of August to enable him to produce. Well, ask for original service book. Service book.
And other relevant records also, my
lord. In original of the respondent number 4, along with other relevant records. Registered respondents may also file affidavit if so advised.
Your lordship, may I have your leave to?
Yes, yes, you take it back.
हम वो ओरिजिनल नहीं बोला था पार्टनर नहीं ये बोला ये बोला है और हमको उस दिन ये नहीं बोला कि ordinance की बात करो नहीं ये
Oh, this is, huh? Why this?
I don't know. नहीं आप इसको देखिए लेकिन अभी अभी लेकिन हम नहीं कर रहे हैं हम काम नहीं कर रहे हैं आई वांट रिकॉर्ड ये हम नहीं बोला यार अरे आपका ये गलत है इज इट रॉन्ग हम अभी आपको सिर्फ कर रहे हैं
डेफिनेटली रॉन्ग सी 2018 वो जो अपना नाम को करेक्शन किया है इट इज नॉट
नाम को देखने एक्सेप्टेड है ना आप तो नहीं आदमी सेम है आई विल एस्टैब्लिश दिस मैन सेम लेकिन आई डोंट नो हां जबरदस्ती पार्षद नहीं हो रहा है केस में हम लोगों को अपना ड्यूटी से करने दो पर्सनली
Item number 7. My lord, there is interim order that may be continued. My lord.
Who had made a mention?
It was mentioned by, I think,
Okay, all right.
leading also.
Item 11. Interim order was, I'll just continue till minutes.
Number 36.
May I say, my lord?
Yes.
My lord, respondent, my lord, have filed their opinion, my lord. I'm pray for some time, my lord, to file a reply, my lord.
How much time?
3 weeks, my lord.
Mayor, my lord. There is some difficulty here, my lord.
What
Because
difficulty?
interim order is in operation, my lord.
Huh?
Interim order is in operation, my lord.
Yes.
My lord, so I would be much relying on the writ petition, my lord, whether the order passed by the authorities was arbitrary or mala fide.
It was passed arbitrarily and malafide.
Yes, on that issue, my lord.
Ah.
Because the work has been awarded to L1. my lord.
Ah.
How L1 was, my lord, prepared, my lord. That is what I would like to demonstrate, my lord.
Yes.
My lord, page 68, my lord.
Page 58.
68, 68.
68.
Yes. Of the writ petition.
Yes.
This is the rate prepared by the department. As per the market value of the items. Analysis rate, 13,300 for item 1. Quantity 635. Analyzed rate 13,300. Now, when we account it in the means of percentage, 80 enterprises, the petitioner hearing, the variation should be in 5%, plus and minus 5%. It should not be beyond 5%. So, my lord, may I please come to 80 enterprises, my lord. The rates quoted by 80 enterprises, my lord. The percentage here in my lord. 80 enterprises, my lord, minus 6.02, my lord. And then, my lord, this is above minus 5. my lord. Again, my lord, 21.89. It is much beyond, my lord, the permissible limit of 10% also, my lord, as per CPWD, my lord. Now again 76% my lord, above, my lord. 96% above, my lord. 94% above. 53% above. Minus 19, my lord. Minus 31. Minus 63. 53 plus. Minus 11. Minus 41. 1,661, my lord. 0.3. My lord, all the rates quoted by the, my lord, petitioner is abnormal, my lord, and not within the justified rate, my lord, of 5%, my lord. So why, my lord? So why, my lord? Your lordship may please come to page 63, my lord. So why the board had concluded, my lord, page 63, my lord, of the writ petition.
Let him file affidavit in reply. Mr. L. Parnell, counsel for the petition.
I am the private respondent. Also, the particular of time. They were you. So like in the.
Oh, yes, you had given time earlier also.
Yes, my lord.
In the face of the base case law. May I be done time. To 70. That is our high court rule also permits to file the result.
17?
7 days. A week time as per our high court rule to file the result. That can be permitted in the most cases. If not, there is nothing in the merit. Nothing on the merit. Even that NG that's limited judgment.
No, the phase 69 was looked into at the motion stage. And Pichai has prescribed such a complicated method of calculation. That is why.
That's why that.
See, NIT method should be as simple as possible, so that there's no complication in there. They make it so complicated, point this, they justify that, what not, then you get scope, then you get a lot of scope for arguments, isn't it? More you write, more mistake there will be.
That's why.
More you say, more, and there will be more scope for arguments.
The common parlance, they say law is so complicated. But the tender process that happens in Arunachal has gone beyond the complications. Just to create intricacies where this court, including the counsels who are representing the case, are not expert.
That's why we don't devote much of the time in a tender matter.
So therefore, that if I place on two authorities, Mahabinda and the NG Pudar, this case goes on base of those. I'll not pray for execution on the laws.
Mr. L. Parnell, counsel for the petitioner. Mr. B. Pichal, standing counsel for the RD department representing respondents 1 to 5, I think.
Yes.
1 to 5. And Mr. T. Tal, and the counsel for the respondent number 6. And the prayer of Mr. L. Parnell, and the counsel for the petitioner. 2 weeks further time is granted.
There is 3 quarter operating and
More
than 20% calls have been
granted for filing of a rejoinder to the counter affidavit. Filed by both the respondents, you also? Okay, okay. Filed by the respondents. As per the counsel for the party, you want to fix that? 17th of August. After Independence Day. Okay, 16. Okay.
Complicated, my lord. Problem here is, my lord, I have filed some RTA application, my lord, to the authority, my lord. If they furnish me the information, my lord, within 1 week, my lord, I can file the rejoinder, my lord, immediately, my lord. Now, when they will file my.
It is not even 2 weeks. 16.
Well, normally the rule is our High Court rule permits 1 week only to file the rejoinder.
Already 1 month time has lapsed.
No, my lord,
If you open up the High Court rules or any other rules, you will face question. Anybody who opens up the rule will face question.
So better.
We are all aware of it. High Court within how much time, counter affidavit has to be filed, within how much the reason has to be filed. But if anybody points out that person, that counsel or whoever will face questions. 17th.
Yes,
Ah,
it's okay.
Oh, 17th.
Great.
Yeah.
Hmm.
I'm in the number of only instruction of him,
Oh, yes. This, all that, I got. The I is for withdrawal of the writ petition, isn't it? Okay. What, Mr.
L Tenny.
L.
Tenny.
Tenny.
Yes.
Learned counsel appearing on behalf of Mr. K. Tari, learned counsel for the applicant. This interlocutory application has been filed by the applicant. However, prayer has been made to withdraw the WPC 74 AP of 2022, sorry, 2020, filed by the applicant. First, prayer is allowed. The writ petition. WPC 74 AP of 2020. So, okay, all the time.
My lord.
Prayer is,
With liberty.
prayer is. Liberty also yourself?
Yes.
Okay, with liberty to file a press if so advised first. Prayer is allowed. I since dispose of in WPC and view of the order passed today in IA number so and so. The petition is sent dismissed on withdraw with the liberty granted to the petitioner to file a fresh writ petition if so advised. Yes.
Yes. Initially, this case was clubbed with WPC number 66 of 2013. And argument was also made on 26/10/2021. Accordingly, judgment was also given. So, but while the judgment was given, 287 WPC number 287/2014 was not mentioned. But argument was made for both. So, in view of the judgment given in WPC number 66/2013, it became infractious.
Mr. Navam is nodding in disagreement.
No, madam. Rather, I'm agreeing.
Oh, you're agreeing, okay. Then we'll say this resolution has become infructuous in view of the judgment passed in WPC 66.
Yes.
Okay.
Yes.
You are for the petitioner.
I am for the petitioner.
Okay.
And now it has come to the re-appeal and the judgment was given in my favor. Division bench.
All right. Mr. M. Patel, the senior counsel for the petitioner, and Mr. Aris Naval, the additional advocate general for respondent number 1 and 2. Anybody appearing for respondent number 3? No. Okay. Anyway, since it is infructuous.
But in other case, Mr. Rintu Shetty here.
Okay, all right. Mr. Patel, the senior counsel petitioner submits that in view of the
Judgment.
judgment and order
26/10/2021
dated 26/10/2021,
in WPC number
passed in WPC 66 of 2013.
13
This writ petition has become infructuous, to which, well, infructuous. Mr. Aris now, an additional advocate general, is in agreement with the submission of Mr. Patil and Sri Rama petition. In view of that, this writ petition is closed as infructuous.
Yeah.
Well, this item number 24 is 2017 matter. This is regarding my lot urbanization of Daimuk town area.
Which area?
Daimuk, my lord, Daimuk, yes. Some area has been included so that urban can be declared, my lord.
Okay.
So against that, my lord, some people they challenge that notification. my lord. But since 2017, no one is coming up, turning up from the petitioner side.
On last occasion, T. Tawa had appeared to petitioner.
Yes,
Then before that, SK Deori had appeared. Deori was here yesterday.
Deori, yes, yesterday was here, but this morning, my lord, let me see.
Do you think matter survives?
Matter survives, but they may not be interested too much. Here is the case, very interesting. The petitioner himself, one of the signatory who supported that this area should be marked for the urbanization.
Okay, now his petition has been filed. No, they want to
Yes.
be at the rural area.
Yes, they want to be in Panchayat. madam.
Okay. None appears for the petitioner. Heard Mr. Aris Nawal, an additional advocate general for the state. Writ petition is dismissed for default and non-prosecution. If they are interested, they will come.